The burden of proof question under Title IX for a universally recognized issue, campus sexual assault. Let's say good afternoon to Adrian Lawrence of ESPN.com, who says Yale used the correct standard of proof in the Montague case. Samantha Harris of Fire.org is critical of that standard, writing, quote, most of us would be categorically unwilling to accept a more likely than not standard in other critical areas of our lives. Ladies, welcome. Adrian, why do you believe Montague's case was properly adjudicated by Yale?
Well, it's my understanding, based on what his attorney had conveyed in the statement that he issued the other day, is that Montague was given an opportunity to have a hearing, to have witnesses, to present the information that he believed supported his case. Nothing seemed to suggest that in any way that Yale's process was incorrect, or that the standard that he was given, preponderance of the evidence, which is what the government says is the appropriate standard and is a standard used in Title IX civil cases, was incorrectly applied.
But this, obviously, you'll recognize, is something that has grown with pushback since the fabled Dear Colleague letter. Department of Education about 5 years ago changed the landscape. So this is just part of a larger matrix, is it not?
Absolutely. It is part of the matrix. But right now, the preponderance of the evidence standard is sufficient for these Title IX cases. All
right, Samantha, you see it differently. And why is that?
Yeah. So, you know, it's not just about the preponderance of the evidence standard. The preponderance standard was laid on top of university judicial systems, which often already do not offer a fair process to students accused of sexual misconduct.
How so?
Well, so for example, at Yale, the right to cross-examination, which is critical in cases where credibility is at issue, such as cases like many sexual misconduct cases where there are no witnesses to what happened. And yet many schools, including Yale, don't guarantee students the right to cross-examine. So for example, at Yale, students have the opportunity to offer written questions to the hearing panel that they would like to have asked of the other party. But the panel has the quote-unquote sole discretion to decide which, if any, of those questions to actually ask. Students are also, they're allowed to have an advisor, but the advisor is not allowed to participate in any way. So you have, 18, 19-year-old students essentially defending themselves against accusations of what is considered to be one of society's most heinous crimes, with very little assistance and with little to no opportunity to confront their accuser.
Is that an accurate criticism or an accurate observation or characterization, Adrian?
Well, the instance here, and also in the instances in a lot of schools' cases, is that you have the opportunity to have this hearing, to have witnesses, and to present the questions. It seems the concern that Samantha Harris has raised is that you're not getting a full-blown trial, and you're not, because this isn't a judicial system. This is an academic hearing in an academic setting with academics who are often laypersons that are addressing these issues that have been raised before them. They don't have a full book of rules, the formal rules of evidence. That's not what's going on here. And also, this isn't a criminal trial. This is a civil engagement going on in an academic institution. So to be able to have cross-examining witnesses, lawyers and whatnot, you cannot turn that academic environment into a full-blown judicial civil trial.
All right, Sam?
The problem is that, this sort of highlights the difficulty of having campuses adjudicate these cases in the first place, because it's all fine and good to call it an academic proceeding, but the reality is at the end of the day, you have someone with a permanent finding of, expulsion or suspension for sexual misconduct, which, to the untrained ear is considered and should be considered one of society's most heinous crimes. So it's not the same as, a finding of responsibility for plagiarism. It carries a tremendous stigma, as it should. But because of that stigma and because of the seriousness of the accusations, it's not something that campuses can afford to adjudicate without giving students very fair process, which too often they don't.
Then, Adrian, how do you reconcile what is generally by all parties recognized to be a serious pathology on campus, sexual assault, all of that issue, the question of consent and whatnot, and the rights of the accused and the rights of the accuser? How does that all work correctly? Is this system good enough?
This system, it is sufficient for what they're dealing with. The loss and the interest at issue here, what that accuser faces, is the loss of not being able to attend that academic institution, not being able to get education from that particular institution.
Isn't Montague's name, though, rather damaged at this moment? And perhaps by choice he's gone public, but he's also a prominent Yale student. There's damage beyond just simply an academic penalty here, is there not?
Well, the good thing in this case is that there is confidentiality. He opted to go public with the circumstances and what ended up happening to him. But he did have that confidentiality there and where he was going.
Sam, we've got 30 seconds. What's the trend here legally?
The trend is that more and more students are bringing these kinds of lawsuits challenging the way they've been treated. There are more than 85 lawsuits that have been filed by accused students in federal and state courts since the Dear Colleague letter, challenging university proceedings for being unfair. And courts are increasingly starting to recognize that students are entitled to certain rights in these processes, and it's a very quickly developing area of the law.
And about this time tomorrow, Yale getting ready to tip it up in the tournament without their former captain. Adrienne Lawrence, Samantha Harris, ladies, thank you so much for joining us.